We have a great topic tonight. How to address smoking issues in your co-op or condo and how to deal with troublesome residents. We have David Amster, the chair of the Advisory Council of Managing Agents of the BRI as a speaker. We also have Carl Finger, a well-known attorney with Finger & Finger, a professional corporation which serves as chief counsel to the CCAC and the BRI. I don't know who's going first. It's going to be Carl Finger. Ladies and gentlemen, please welcome Carl Finger.
Hi, good evening, everybody. Thank you. Always rare that I actually get applause. So I want to. I think the handouts that I have are on your tables. I'm going to go moderately quickly through them because I've had several people already prompt me with questions and looking for some advice. So I know that may be the best value, the best bang for your buck this evening. So thank you, BRI and Jeff and Tim for having me, and for David for doing this presentation with me. David's going to jump in and interrupt me as often as necessary, but also will be able to answer questions. The two parts to the presentation, and they're fairly related in certain ways, are the problem residents, problem shareholders, problem unit owners, which is the packet I have enforcing your house rules, because when it comes to problems, you want to enforce your house rules. So pretty much that's that, and I'll go through that. And then the second or first part, which I'll talk about, is smoking, what to do about smoking. And there's two answers to that. The first part I'm going to talk about is how you deal in general with smoking, whether you should or not. And then the second part will be really part of your house rules and how to deal with issues when you have a rule on smoking and somebody, I know it seems impossible, but somebody doesn't follow the rule. So I know it doesn't happen to anybody's buildings here, but it has happened. So real kind of quickly on smoking. Over the years, we've had a lot of change, obviously culturally. Everybody started coughing about the person next to them, and arguably progress, was made in terms of where smoking is allowed, how it's allowed, etc. Starting with public places, restaurants. A little side note, I used to go to a diner, and the diner added a bar in the back. And I said, why'd you add this little bar? It doesn't seem like you really need it. And he said, well, the thing is, 2 nights a week, the people from Alcoholics Anonymous come here and they like to smoke. And you can only have smoking if you have a bar. So it's a little odd that smoking actually, well, I don't know what happened, but they didn't keep the bar there for long. I don't think that was a good combination. But anyway. 1986, you had a Surgeon General's report about smoking. 2006, you had a Surgeon General's report about secondhand smoke. And I think secondhand smoke is really where the rubber hits the road for places where buildings where it can become an issue, either because people are smoking in public areas or even in private areas. And 2010 was sort of the watershed New England Journal of Medicine study that essentially was focused on public housing and the sort of detrimental effects of smoking in public housing, but a big part of it was the fact that secondhand smoke gets into the building, gets into the apartment, gets into another apartment, gets in the conduits, and basically stays forever. So, and that the second half of that is it is truly horrible. There's no risk-free level, and it's a known carcinogen. So it is a legitimate concern for those who are living in proximity to somebody who's smoking. It goes between the units, etc. So, essentially, if somebody is smoking, it can have an impact, and as a result, a lot of buildings, starting not only with public housing, which most public housing now does not allow any smoking, it includes any multifamily housing where if smoking is happening, it can have a negative impact on non-smokers. In addition to the obvious health issues, there's many statistics on fire starting as a result of smoking, So it's really something that has been under serious consideration for a number of years as to whether to permit it only in public areas, or ban it altogether. And there have been some positive impacts of eliminating smoking altogether, in terms of values, in terms of shareholder or unit owner complaints, and in terms of reducing some of the maintenance associated with the odors and other things like that that can be caused by smoking. So, what to do? And I don't know, how many people, maybe I should just ask, how many folks in this room live in a building where there is a rule associated with smoking in the building? Well, a rule associated with how many people have a rule that says smoking is not permitted at all whatsoever in the building? Okay. How many people have a rule that bans smoking in public areas? Okay, wow. All right, so that's interesting. So what we see here tonight is almost everybody has a rule that bans smoking in public areas, and a few of us have rules that also ban smoking in individual apartments, it sounds like. So one of the things to decide, which you've already, at this point, what's interesting is several years ago when I took that same informal survey, I would say very few people raised their hand as to any rule at all whatsoever. So we're definitely seeing a change. The question now becomes, and I think banning smoking in common areas is probably a pretty easy lift. You're not going to have a lot of controversy most likely about it. You can clearly do it with an amendment to your rules. You're not likely to face a legal challenge to that. The more difficult scenario, which is similar in dealing with troublesome unit owners or shareholders, is the individual apartments. If you have a condominium, you're dealing with a declaration and bylaws, and that's going to be, and house rules, but that's going to be a little more difficult. If you're dealing with a cooperative, you're going to have either a change in house rules or a change in the proprietaries. So why would you do one or the other? Change in the house rules, the board can do, generally speaking. So easy, if you have a consensus, if the board agrees, you can make that change by house rule. Changing the proprietary lease, more difficult. Generally, you need a supermajority of the shareholders to do that. You probably can't get a majority to agree on much of anything, and getting a supermajority, if you can even get a quorum at your annual meeting to begin with. So what happens is you have to amend the proprietary lease is a major undertaking. It's clear that amending the proprietary lease, if cooperative were to do that, would be sustainable from a legal standpoint. It's not quite 100% clear that if you amend your house rules to ban something like smoke inside the apartment, if it's not impacting your other shareholders, and we'll cover that in the violating house rules section in a few minutes, it's not 100% clear that a court would uphold the board's exercise of its discretion. There haven't been any cases really challenging it, although there have been cases where courts have found that smoke emanating into somebody's apartment interferes with their habitability of their apartment, and courts have granted abatements where the landlord has not done anything, or the cooperative or the condominium. So you have to really be aware of that when you get those complaints. But in any event, house rules is certainly the easiest way to do it. To be candid about it, even if you don't have even if you do it that way and you change your house rules because you want to ban smoking altogether, which whether if that's something you decide to do, oftentimes it's not going to be challenged. So we've seen it. That's why we haven't had any court cases about it, because I know that their buildings have done it. They haven't been challenged in court. People have most often just abided by it, or they've gotten equipment like smoke heaters and systems that take in the smoke, so it's harder to detect, which solves the problem as well. And we've had some success with that. So you should consider it if it comes up, whether you want to adopt a policy banning smoking altogether. If you do, it's definitely worth surveying your shareholders. It's definitely worth communicating with your shareholders and your unit owners and making sure that they're all on board, or as many as possible are on board. If you do that, the next thing is, once you adopt the rule, to make sure that we notify everybody and make sure that everybody's aware of it. And then your next step is going to be the enforcement of the policy when somebody violates it, and I'll get to that with troublesome shareholders in a moment. And those are the main takeaways from that. So let me see if David has anything to add, and then we'll deal with more general.
Yeah, no, Carl's right. In addition to me being the chair of ACMA, I am also president of Prime Locations, which manages over 6,000 units here in Westchester County. And I have a lot of properties very recently where the smoking issue is coming up. And it's usually 1 or 2 shareholder complaints, and then it balloons into a lot of issues going around, and more shareholders are talking about it, saying, hey, we don't want to breathe in secondhand smoke. But how do you actually go ahead and come about and turn a building no smoking? I'm about to have my first successful no smoking building come on board. And it's being done through an amendment of the proprietary lease, which is really the best way to do it. I mean, a lot of buildings have put in no smoking rules in the house rules, but I guess, as Carl said, the enforceability, usually they put fines on it, and usually the proprietary lease may not allow for fines, and you get into court situations, and it doesn't really flow as well. So I've had a couple of buildings try, but the best way you can do it, if you're looking to turn your building into a non-smoking building anywhere in the building, is you really have to plan. And you have to know your shareholders, and you have to know the concerns, and you have to know the makeup of your building. Because if you have a sponsor who owns 30% of the building, or 20% of the building, and he's totally against it, your chances of turning that building non-smoking, needing usually 66 2/3% vote, is not going to happen. Because there's always going to be shareholders in the building who don't want to give the board that power, who feel, even though I'm against smoking, it's a problem because I really can't, I don't want to tell my neighbor they can't do something in their own home. So it's a problem for a lot of buildings to get that super majority, and it takes a lot of work to do it. It's not easy, you got to be organized, and the board members have to be willing to go door to door to door to actually get people to vote on it. Because as Carl said, and my experience is, you very rarely get the 51% to a quorum of a shareholder meeting, let alone a supermajority that has to vote positive on the amendment. So my latest building, they had a meeting about 2 weeks ago. They called the meeting a month before, and the amendment was out there to ban smoking anywhere within the building, in the apartments, and it includes vaping, it includes marijuana, it includes everything, and within 100 feet of the outside perimeter of the building. That was the amendment they put forth. The board decided we're going to go door to door to door. Before the meeting, they went out, got proxies. We came to, and the meeting was called in a manner, and I guess Carl can talk to this, where there was no adjournment at that particular time. They kept the meeting open for another month after the actual meeting. So if we didn't collect everything we needed that night at the meeting, we could keep going back, knocking on doors. So this is 2 weeks ago, we had the meeting. We got about, let's say 55% of people voting. The board had a lot of those votes in hand before they attended the meeting that night. They had collected a lot of proxies. A few people showed up to hear, what was going on, what's it all about, and what if a guest of mine smokes in the apartment, what if somebody gets caught outside smoking, on the terrace. This is anywhere on the property. We got very, very close, and today, we are, and the average apartment in this building has like 150 shares, we're 82 shares short, with about 11 apartments left that haven't voted. So I'm pretty confident they're going to reach that goal. But this building did not have a sponsor. They had a sponsor on 2 apartments. It really wasn't a big deal. So you really have to know. I have another property that really wanted to go no smoking. The sponsor owns 24% of these shares. I called the sponsor. I said, what do you think about this? Before we go through, excuse the expression, the legal fees and everything we have to do to get it going, before we actually called the meeting and went through all the expense, I called the sponsor. He said, no, I'm against it. I think it's going to hurt my sales or rentals or what I have. So we're going in 24% down right at the start. It's going to be almost an impossible task. And we know there's a few people in the building who smoke who aren't going to vote for it. So at that point, what's the point? You can amend your house rules in that case and try to enforce it that way, but you're never going to get that ironclad total no smoking ban. But today we're even more so than cigarette smoke. We're getting marijuana smoke in the hallways, and that's become a bigger problem a lot of times to control. It's very pungent. You can smell it. People don't. I had a board member who was trying to sell their unit. Their neighbor's smoking marijuana. And, people walk into the building with their real estate broker, it's not exactly well, maybe it is a good impression, I don't know. It depends. But I think it's really important, that if you're going to undertake the project, know what you're getting into, know what your makeup is in the building, and be willing to knock on doors and, split it up, talk to your neighbors, try to get those proxies signed. And if you, have the ability to do that, it can be accomplished. And I think, this one, by tomorrow, I'm sure it's going to get accomplished. So, it's difficult, it's worthwhile. A lot of people don't, want to live, years ago, I remember going out and go to a restaurant, go to a bar. Yep. I'm a managing agent, I go to a lot of bars sometimes, But you go out and you came home and you practically had to leave your clothes outside. Nowadays, if you happen to be, I went with my wife down to Mohegan Sun, and you're in a casino, and your eyes are tearing from the smoke. So you're much more sensitive to it today. I think a lot of people are a lot more sensitive to it today, which leads to a lot more of the complaints we get. Carl?
Okay, so I'm going to cover the scenario of once you pass your proprietary lease amendment or house rule, what happens when somebody breaks the rule? You're a troublesome person. So I want to run down some general things. I'm going to hit on a few of the common problems without really necessarily answering them. And then to give you something to think about and questions you might have on these subjects. And then some basic procedures, and then we'll open the floor to questions. So generally speaking, house rules are going to be your day-to-day list of items in addition to your proprietary lease or your declaration of bylaws in a condominium. That's where you want to basically indicate what's permitted and what's not permitted. And we're going to look at those for things like how you maintain the quality of life for your shareholders that they expect, how you maintain safety for your shareholders and unit owners, how you deal with potentially sublet and rental policies, move in and move out procedures, move in and move out fees, alterations for apartments, which have multiple issues because they affect not only the person who's living there, but potentially the people around, potentially the whole building when they're having contractors coming in and out. Pets, emotional support animals, noise, and I have smoking listed here. So these are all kind of your common areas where you're going to find that your rules are very important. It's always a good idea to periodically review your house rules, update them, make sure that they're pretty specific as to whatever the issue is that you're trying to address. Make sure that you define anything that needs to be defined in terms of terms. So for instance, smoking, you want to say smoking is all smoking, not smoking, not cigarette smoking, be careful. That's another reason to update your rules. What was a problem yesterday, or 10 years ago, or 30 years ago in the 80s, or 40 years ago in the 80s when a lot of the buildings were converted? That's not necessarily what's an issue today. And then you want to make sure in general that the rules are enforceable, but usually they are. In terms of enforcement, just general rules of thumb. If you adopt rules, when you go through your rules, when you update them and make changes, you want to circulate them, make sure everybody knows what the rules are. You want to highlight changes if there are important changes. And if you're going to start enforcing a rule that hasn't been enforced for some reason in the past, let everybody know. So I've seen buildings where there was a rule about, what could be done in the front door, what could be done in the back door. They changed the rule. Nobody knows. They start getting, letters from the managing agent because they watched on video and saw them bring their dog or emotional support animal out, wherever. So I think it's always helpful to make sure everybody knows before we start enforcing. In terms of enforcing the rules, so the first thing that's going to happen is you're going to get most likely, either you get a complaint or somebody sees something. If it's a complaint especially, we recommend that you verify the complaint if that's possible. And depending on what that complaint is, if it's noise, it could mean asking a third party, the superintendent, porter, property manager to attend when the noise was happening, a board member, somebody to make sure that, yes, this is really a problem, it's not just a super sensitive neighbor. And I think that can be very helpful. But also, if you really have a problem, all kinds of equipment and things like that. But you want to verify the problem, and once that's done, the first thing generally is your property manager, your managing agent is going to hopefully be involved, and they'll communicate with the offending person. And that's maybe a phone call, but if it is, it's a phone call followed up with a letter. You always want something in writing. The first thing should not be calling Carl Finger or Ronald Schur on the phone and trying to get legal action, because these still are your neighbors, they may not realize. Another thing with noise, you can inspect to see if the person who's creating the noise is complying with the carpeting requirement, things of that nature. So you want to do your diligence before you send the letter, because you don't want to get a response and find out that it's wrong or whatever. And sometimes the problem can be solved just by communication, and people don't always have the best communication. So, for instance, I was, when I lived in an apartment, I was downstairs and there was a noise every Saturday morning at 7 o'clock, and I thought somebody was playing ball upstairs because it was rolling across the floor. And I never heard it before. And after about 3 weekends of this on Saturday and Sunday mornings, I put on my bathrobe and I stormed upstairs and I knocked on the door, and a lady came to the door, and she was a young woman, and I didn't recognize her, and I'd been there for a number of years. And I said, "Oh, I don't recognize you. You must be new here." I said, "I'm sorry, but whoever's playing ball is, it's waking me up in the morning on Saturdays, and if they could just stop rolling the ball around, it would be great." And she said, "Oh, well, the lady who's the tenant here is in the kitchen. Why don't you come in?" So I walk in the kitchen, and of course, it's an elderly lady with a walker. And she had just had surgery. I knew her fairly well from a number of years, but I didn't know she had surgery. So she apologized, which made me feel even worse. She had heard the whole thing. So anyway, communication can help. But I will say this, I felt terrible, I apologized, I said, make as much noise as you want. But I don't know what she did, but I never heard it after that. So anyway, so sometimes people aren't necessarily talking to their neighbors anyway. And if they're not talking to their neighbors, the neighbor doesn't know, a call from the agent even before a letter with a follow-up can really avoid, as I said, the lawyers getting involved. If that doesn't work, then the lawyers can get involved. Again, you're going to want to document everything with your property manager will know how to help you with this, your lawyer will know how to help you with this. Everything should be documented by the time it comes to the lawyer, so the lawyer has a full panoply of information to rely on. Generally speaking, the process in a cooperative is going to indicate the service of a notice to cure, and if the problem continues, notice of termination terminating the proprietary lease. It's rather drastic in a way, because that means the person will eventually get evicted, but typically that doesn't happen. They get that notice, they don't want to lose their apartment, things get worked out. Sometimes you end up in court, at which point all that documentation that your agent has helped you put together will be very valuable. In a condominium, it's a little different. It's definitely more difficult. In a condominium, you're typically going to end up going to Supreme Court. It's going to be much more costly and time-consuming. So your lawyer will try and do some things, hopefully before going to court, some letters, some cease and desist notices, things that are not necessarily effective, but will hopefully work. So if you get to court, you will need to be prepared, and the people who are complaining will need to be prepared to go to court as well. If somebody's complaining about noise from upstairs, and then you go to court and they don't want to show up in court, you know, not so great. They've wasted your time, your money, etc. So I think at some point it's good to be clear with the complaining parties of what the expectations are. If the board is willing to go forward with a case, that they need cooperation from the neighbors that are complaining. One thing I skipped over, but I shouldn't, is fines. I think David mentioned it before. First of all, fines have to be permitted in your proprietaries, if you're a co-op, in your governing documents, if you're a condominium. That having been said, even if fines are authorized, there is a potentially limited impact. So you issue the fine, a month later the problem's still happening. The fine didn't work. My suggestion is, don't fine them month after month, hoping that one day they'll suddenly care. That's when you get one of your attorneys involved, your agent involved, what's the next step? Because you really want to solve the problem. You know, fining is a sort of a roundabout way of solving the problem. If it doesn't work, meet the problem head on, serve the proper legal notice, and go from there. And hopefully, you know, you'll get a resolution. Most people want to get things resolved. There are certain circumstances, I should say, where you may want to have give the shareholder who's supposedly causing the problem an opportunity to be heard, come to a board meeting, make sure they understand what the problem is. You may want to, different options that may bring people together as opposed to going to litigation and potentially creating more animosity, and spending money. So I think that's kind of the nutshell version. I have a whole bunch of other thoughts, but I want to hear the questions. So let me turn it over to David for a few minutes, and then...
Carl, I just want to bring up one issue. We had two boards where the board president is a smoker, and we have a board member who's creating noise. It's always a problem with a conflict with the board trying to resolve it. So we've tried to step back, bring in Westchester mediation of cluster to facilitate that so that the board is not in a potential conflict or there's even an appearance of a conflict to try to get that resolved, especially that it's a board member.
That's a good point that Ron made too. Noise complaints are the worst complaints we deal with as managing agents because we hear them every day. And, you know, it's usually not 9 to 5 or whatever, they're mixed hours. You know, a lot of people today work different hours. It's a 24-hour world. Somebody may be getting up to go and shower at 2 o'clock in the morning to go to work, and you may be trying to sleep. So there are a lot of different things involved. But the noise complaint, neighbor to neighbor, I mean, it's usually somebody's walking around in the middle of the night, or we hear kids running around during the middle, in the daytime, at 10 o'clock, 11 o'clock in the morning. Is that really a noise complaint? So what we do, the first thing we do, and the only thing we can do at first, is we will first ask for the resident to give us a complaint in writing. You want to have that documented. And then we will go, and most of our properties have, I'm sure almost every proprietary lease contains this language, or house rules, a carpeting rule or soundproofing rule. Buildings enforce it, sometimes not 100%, but if there's a complaint, you have to go look. And the only thing you can do when you walk in there to see noise, unless somebody's banging around upstairs while you're there, is to see, do they meet the carpet rule? And 80% is some of those house rules maybe should be written to a little bit higher extent. 80% of carpeting, with padding, maybe it's 2-inch padding, maybe it's, to a more extreme extent, because 80% carpet in the original house rules that may have, a lot of times it means 80% of a throw rug thrown down, a thin throw rug, and it really doesn't do any good. So I have one building that went to a 100% carpeting with the exception of bathrooms and kitchens. That way it's totally, and it has to be wall-to-wall carpeting. So not, or they have to put in some type of sound insulating material that's proven to certain acoustical region, what it is. So it's important that when you're, looking at house rules, the noise complaints, it's constant. I mean, I don't think there's a day that goes by that, 10 don't come into the office from properties. But the only thing you can do is get the neighbors together. Sometimes people don't realize it. That's one thing. That takes care of that. Sometimes the neighbor doesn't want to go knock on their door, so they let the managing agent or a board member or somebody get involved. and then it calms down. A lot of times, some people may be too sensitive, are not used to living in apartments, or the person who lived upstairs for 40 years moved out, and now there's a family with 2 young children in the apartment, changes the whole noise structure of the building and the apartment. So these are things you gotta be sensitive to, but make sure they adhere to the house rule. And as Carl said, you have to change your house rules, you have to adopt your house rules over time. And you know, if you're doing things in your house rules and you're changing, you're taking the time to go through them, you know, address the carpeting rule. Make sure it is, you know, if it's 80% or 90% or 100%, but it's adequate padding, adequate soundproofing so that it doesn't affect, you know, your neighbors. And if all else fails, usually it turns into upstairs is making noise, go do an inspection. Oh, well, they're making noise downstairs. Go do the inspection downstairs. Oh, by the way, you don't have carpet either. Now you have to get carpet in your apartment. You know, sometimes it can be solved, sometimes it can't. Sometimes Westchester mediation we call in to try to mediate the situation. But at some point, you do have to take an action. Otherwise, there's going to be liability on the board for not taking any action. So it's really, you know, leaving it up to professionals. Get yourself involved, get everything in writing. Tell people if they get complaints, call the police if it gets to that thing. So there's documented proof that they made a complaint at a certain time. And, you know, and then hopefully it works out or somebody moves.
I'm going to get a question, 1 second. I just want to say one other thing. I think one of the important things you could do when you get a complaint as a board member is make sure it gets to your property manager and your managing agent promptly. And if they think it needs to go to your attorney, that goes to your attorney. And that at least you start the process of dealing with the complaint right away. You know, sometimes you get a complaint and maybe it's a Monday and you'll bring it up to the board meeting. Board meeting's in 4 weeks. Well, over those 4 weeks, the problem escalates. So that's why they're here, that's why we're here, to start getting that process going. And also, if you're getting a complaint from somebody, putting aside speaking to the person who may be causing the problem, as David said, the property manager will speak to the person who's complaining and maybe tell them, keep a log if it's noise. I mean, a log book indicating the date, the time, the type of noise is very important. Or when they smell the smoke, or when they hear the dog barking, or whatever it is. So, you know, use your access to your support liberally, because a little extra time, an extra phone call at the beginning, an extra call to your lawyer will save you aggravation at the end, where it turns out, well, we should have done this at the beginning and now we have to start over again or whatever, which happens. So, yes, Stuart. Oh, wait, I think, no, but I think it's being recorded, so we want to get it recorded for posterity.
For the purposes of posterity.
Hi. With regard to carpeting, I just want to say, what I've done to avoid confusion about the interpretation of what is thick carpeting and what is not, I asked the shareholder or the resident to bring a sample of the carpet and the padding. So there's no interpretation problems. Well, I thought you meant this, or I thought you meant this. No question. In terms of settling disputes, I found that when all else fails, reminding the offending parties, either one, depending on the weight of the evidence, the co-op or condo has deeper pockets than they do. And if it's going to go to court and they're going to fight a reasonable solution, that's worked in an incredible number of cases. Just remind me about the financial idea of them suing the co-op for failure to do whatever is necessary. So just remind them, you want to go to court, let's go to court. You have that kind of money, fine. And all of a sudden, they're beginning to think down the road a little bit. So that sometimes can be very effective, I find.
Yeah, first, a comment. 80% of carpeting, and you have to be careful to say 80% per room. We had a shareholder who said your regulations say 80% carpeting, so we can carpet everything except that room. That room doesn't have to have carpet. So it's 80% per room. Now, what is the supermajority? 66% or 75%?
Depending on, usually it's 66 2/3. Sometimes I've seen it at 75.
And is it the number of units? 62?
Shares.
Shares.
In a co-op, shares. And those people have to vote for. It's not you need a quorum of 66, you need a 4 vote.
Right.
Hi, suppose you have a colicky baby that cries all night, and 2 units are impacted, and they complain all the time.
I'll let you handle that
Well, I mean, I would say the first thing you do is bring a pacifier up. I mean, look, you know, I think that, you know, the reality with something like that, hopefully, is yes, you can start with a letter. You can then, if it still goes on, you know, start the legal process, I suppose. But the reality is something that is likely to abate, you know, it's hard to suggest getting on sort of a marathon, which is kind of what a note is with various the legal process is more like a marathon, because you've got to do things and you've got to serve notices and you've got to go to court. By the time all that gets done, the problem's likely to be solved. And it also sounds like the type of problem that a court would be sympathetic to. And the court can always grant more time or, you know, fashion other remedies. So I think, you know, part of that may be some of the basics, like making sure there is carpeting, because that would presumably help. I don't know what other suggestions to have. You know, you suggest that if they don't have carpeting, they put the carpeting down, or put more carpeting, or whatever. But certain things, I think, are you have to take a perspective of what's likely to be the net result of, you know, your actions to resolve them.
Carl, we had a situation like that where we asked the person with the baby to have the baby at certain hours in a different bedroom. Change bedrooms, change the location, see if people could work that out. Because as Carl said, there will be an abatement within 6 months, basically. And it's something that no court, I would never take that to court. I would be foolish, be fatally flawed if I was to go up against Carl Finger, who was defending them. It would be a foolish thing. So it's something that we try to work with them, tell them to be sensitive to each other's needs, and see when the baby cries, move it into another room, so that the abatement could happen due to a change of location and proximity.
Other questions? Other non-infant related?
Hi, I just actually have a statement, but maybe into a question. What do you recommend if you have slamming of doors all the time and loud voices all the time of talking, like 10 people are constantly in the apartment? So, you know, it's very hard. Do you not tell them and go to them and say, can you lower your voices? Or do you tell them, please stop banging the door? Like, I have in the past, because we have porches, that my downstairs neighbors used to be up every weekend at 7, 8 o'clock in the morning, and I'm like, oh boy. And they would be talking and having their coffee, but talking loud and smoking at the time. And I went down to her and I told her, I said, do you mind, you know, it is the weekend, some people like to sleep. And never talk to me again. So, you know, there's 3 scenarios. It's not just carpeting that always makes noise. I mean, he recommended the baby, you know, suggested the baby. We have doors and people and just a lot of different things.
I mean, so my neighbor spoke to me again. But, yeah, I mean, look, if it's a verified, the first thing is you speak to the property manager. They'll you know, you want to get some verification of the problem through other board members, through the super and the porter. You know, you want to verify that it's an actual issue and not just somebody being sensitive. Just doesn't matter.
Can I just say
Sure.
that what if it's the super?
Well, I don't think it doesn't, well, it changes things in the sense that there may be other issues in terms of, you know, if it's a union super or things like that. However, he's still subject to presumably the same rules, the same needs. So you want to go through the process, and the process well, how would you start, and then I'll say what I would. I mean, you would be, I think the starting point would be David, and then,
David has this situation.
Yeah, apparently I do.
David just got this board, so we're gonna.
You didn't tell me this before. You know, realistically, the super has to be handled. It's almost a higher level than a shareholder would be, because you do have some control over the super's employment. You know, it may not be instantaneous, but if it's a constant problem, there are things you can do to that maybe eventually not make him the superintendent anymore. So they have to behave. I mean, sometimes people just don't realize what they're doing. I mean, that's usually what we find. But you have to bring it to their attention, and you have to make it, and in this case of the super, I document it. And you know, you get 1, 2, 3 complaints, I wouldn't have a problem going down to the union with something like that and saying, look, the super's breaking the rules. You know, what do you want me to do? We have to take action. So in those cases, it's almost easier to deal with a super than it would be a shareholder, where both people equally own the units, and you have to deal with 2 people who are, it's usually a he said, she said, you know, they're making noise, I'm making noise. At times I've sat down with, you know, once or twice with board members and the 2 parties and tried to mediate it ourselves. If that doesn't work, recommend mediation with Westchester County. But sometimes there are a number of people out there that are either too sensitive to live in apartments, and you know, different apartments have different, you know, garden apartments have different noise sensitivities than you would in a high-rise. I have a building the other day, we got a complaint, one lady, and she came to my office the other day, she's insisting the people below her are renovating their unit. Now, they're not. They haven't put a renovation package in. We know that the super inspected it. I told her today I would go inspect it personally, but there is somebody else in a different area of the building that is doing it. And sometimes sound travels in different ways. It doesn't necessarily mean it's coming from that apartment. We've had buildings put rules in, you can't hang a TV on a adjoining wall to another apartment. It has to be on an interior wall. That keeps, you know, the surround sound bounces back and off and creates other issues that, again, didn't exist 20 years ago. So those are things you got to look at and, you know, adopt your house rules to, and try to, you know, noise is, like I said, the biggest problem we deal with.
Carl, what do you do with the reasonable accommodation? I can't have carpeting. I'm hypersensitive. I need to have all wood. I know how we do it, but I'm throwing you the softball. What do you do, Carl?
so there are other materials that are non-allergenic. There are underlayments that go under wood floors. There are solutions. You know, the one thing that comes up with that then becomes financial. And you'll hear from the offending shareholder that they can't afford it or whatever. I mean, I don't know where the limits are between what's a reasonable accommodation and not a reasonable accommodation on some of these issues, but we have had some success telling people, all right, don't get carpeting, get padding that's not allergenic, you know. So with your example, though, I would say that putting aside the superintendent issue, you know, the basic procedure is to document the problem, to verify the problem, to have the agent try and solve it, you know, prior to litigation, and then if you have to, you go to court. And there are, to be fair, there are even multiple options for court. We have a case right now where there was another attorney that had handled it. It wasn't Ron Scher. And they tried to go to local court, a local municipal court. It did not go well at all. We brought a case actually in Supreme Court, which is very unusual. But we felt under the circumstances that was the best thing to do, and the result, hopefully, is the person's actually going to move and sell the unit. Now, it took many months to get there, and it's still going to be months, but the idea is, you know, it finally came to, look, this isn't the right place for you, what they were saying in a way. You know, not everybody should be in an apartment. Like, if you want to work out with your weightlifting set every night, all night long, then you can't live in an apartment above somebody else. So, you know, the idea is document, follow the process. You should have the process outlined pretty clearly, you know, at least in your mind and with your property manager and your lawyer, and then take the steps necessary to solve the problem. Yes. Oh, wait, let me give you.
I just want to say, in response to Ron, with your issue with the person who can't have the carpeting, one of my managing agents has gone so far as to volunteer to assist the shareholder below with a sound deadening or a suspended ceiling or something in between in the apartment to create a space where the sound would not travel, and that has also helped to alleviate the problem of a resident who can't, quote unquote, have carpeting in their unit. So that's another possible solution that people can look into.
This is Evelyn Patron giving that answer. Thank you, Abby. Appreciate that.
Thank you.
Carl, you're talking about the question of a walker. Now, if it's a medical issue, like we have that right now in our building, and unfortunately, the individual in the middle of the night or every night has to get to the bathroom, whatever, and is on a walker. How do you solve that problem? You go to court, and this is a medical issue. So what?
I mean, I would look for solutions short of court for that, obviously.
Tennis balls on the walker. Put tennis balls on the bottom of the walker.
Well, we had, I mean, as far as we know, they're doing everything they can.
So the starting point is to take a look and see if they really are doing everything they can. Have your property manager go by, see what the story is with the walker. What's causing the noise, because until you really know exactly what's happening, and your property managers have seen a lot of things and sometimes have creative solutions. So I think that's the first thing. And yes, going to court on something like that, likely to be a little bit of a sensitivity issue. So, let me just say one thing in general. The idea that people are entitled to accommodations is clear. I think we could have a whole separate issue about accommodations. But, a lot of questions come up about what's a reasonable accommodation. And that's where we have to try and find what the right line is. It's not always clear. Courts haven't decided every issue on reasonable accommodation. But a few examples. We had a case where somebody was disabled and she had a handicapped parking space, and then her husband was disabled and they wanted a second, not handicapped, she had a priority parking space close inside in the garage. And her husband, she said, was disabled, and she wanted a second parking space as an accommodation, and sued in federal court. And we were able to win that case, saying that, because they're one unit and one apartment, it actually wouldn't be reasonable. It would not put them in the same position as anybody else. It would put them in a better position than anybody else. We've had dog situations where they want an accommodation to, they have the dog. It's not just having the dog, it's they want to walk the dog, close to the front of the building or something like that. And we found other locations and we've been able to deal with that. So I think there's room to address these issues, but you want to be sensitive because the courts are going to be sensitive, because there's Westchester County Division of Human Rights, which we know is going to be sensitive. But again, I think folks like David have a good shot at sometimes coming up with a solution. If not, take the next step. Yes. Oh, wait. Is there?
Hi, I guess I'll just touch on a couple of things. One, we're talking about the accommodation with somebody who didn't want to rob or something like that. I happen to know personal experience from work. There is art out there that can be hung on walls that is soundproof or sound absorbing, and it does an amazing job actually. And there's now companies that will actually print your art. So if you make a drawing, you take a photo, you can send it in, it'll actually frame it, and it will be sound absorbing. So that's just a potential solution for something down the road. So my other question is kind of like, how much is too much noise, which I think you were just starting to touch on. So we had an incident where actually one of our board members was smoking, and people complained in the building that they smelled it in the hall. So it went on for quite a long time because we never received a complaint about the apartment smell. And they complained about the hall, but how much is too much? The board member, who was supposedly the offender, then installed smoke heaters and caulked up every opening in the apartment and put things under the doors. And personally, I went over to the hallway to inspect on several occasions, and it didn't smell at all. But the tenant upstairs continued to go on, and then once found out that, well, the hallway is not good enough, then it was suddenly I smell it in my apartment. So I guess the question is, how much is too much?
Yeah, well, from a legal standpoint, you know, the board is entitled to exercise what's called its business judgment. So, and I'm not saying this is always works to perfection, but the court is supposed to essentially defer to a board's decisions as long as it's made in good faith, there's no discrimination, things of that nature. So that's where a couple of things come into play that I mentioned before. Verifying, investigating, verifying, potentially giving parties an opportunity to be heard in front of the board. Let them know, we've received this complaint, you know, let us know what your position is on it. Things like that will allow a court to more likely defer to the board's judgment on a close call. And I think that's where, really a board has to, as a group, look at an issue and decide. If, again, you could go to that person's apartment, you can investigate, does the board smell it, etc. That would be certainly well within, I think, your proper dispensement of your duties, and then make a decision. And if yes, you go to his apartment and you smell the smoke, or her apartment or whatever, and you can smell the smoke and it's not good, then okay. If you go and nobody can smell it and you don't think it's an issue, you make that determination. And at some point, you make your best judgment, and if you end up in a lawsuit about it, you hope a court defers to that. And that's all you can do. But if you do the diligent steps, you're putting yourself in the best position to prevail if you end up in court.
So my question relates to access to a unit owner's apartment where they deny you access. How do you handle that?
Why don't you start and then
Well, first of all, in a co-op, in a condo, okay. A little different there? To some degree. Co-op, you would have access because the proprietary lease allows you access on notice to enter the apartment. There are ways to get into apartments if you had to. You could smell gas. You can smell a leak coming down that may be affecting some other neighbors if you want to really get in there and see if something's going on. But I think, in terms of, I think even in a condo, you would have the right to access to do an inspection at some point.
I think it also depends on context, right? So let's say what David said, gas, or you just had a leak. If there's an emergency, I think whether it's a co-op or a condo, and you'd have to look in your declaration and your bylaws to get, exactly the provisions, but they're going to be something. If it's non-emergent and you can't get access, you still, certainly in a co-op, may well be entitled to access, depending on the reason. And in a condo, you might be as well. You'd have to look at the reason, and then there may be, in the co-op scenario, as I outlined before, the process is much more compacted. In a condominium, there is a legal process to undertake, especially if there's a nuisance of some sort emanating from the unit. We've had hoarding is a very common issue these days. We've dealt with that in the condominium context just as much as in the co-op context. It's just the process is more time-consuming and expensive. So depending on what the problem is and why you want to get access, I think you could deal with the problem almost no matter what. At some point in the day, it may come down to a judge deciding, is this really a problem or is it not? But I go back to what I said before. You do your steps, you do your diligence, and you build up a case well ahead of when you get to court. And in building that case, hopefully you may even solve the problem.
We have time for one or two more questions.
I don't really need that. I have a question. It's always my understanding that the board should refrain from getting involved in things. I'm going to the smoking issue. We're a no smoking co-op, but I was advised that board members should not be knocking on shareholders' doors to verify that they're smoking.
No, I agree with that. First of all, board members shouldn't get in confrontational situations with their neighbors. You have to live there, and you're gonna have to deal with them going forward. So it's always better to let the managing agent handle that particular situation. There may be times where somebody would rather, go along with the managing agent if you're gonna do an inspection, but you should not be the one where at 2 o'clock in the morning they're knocking on your door saying, hey, I smell smoke in this apartment, go handle it. That's what we get paid to do.
But it's also very hard to prove that people are smoking. I would say if you smell smoke in the hallway and you know for a fact that somebody's a smoker, that you can make a logical inference that the smoke is coming from that apartment.
So, 2 things. First of all, I agree with what David said. Generally, you want staff, whether it's property management or a super reporter. Sometimes it's just not possible or feasible, but yes, that is far preferable. In terms of where the smoke is coming from, it's a problem. I mean, I don't want to, we know, but knowing and proving, right? Sometimes they're 2 different things. So that could be a problem. I don't know 100% what the solution is. Sometimes you end up in court and you have to have a trial, and the judge will make a decision who he believes or she believes.
It might cost us a lot of money.
I'd like it to be resolved by your property manager.
As far as I'm concerned, since it's building and Dave's gonna be our property manager, I think it's the rule of the nose. The nose tells all. You smell, you have the superintendent periodically sniff the doors. We've also implemented in other buildings, since every building you have has the English muffin effect. It has nooks and crannies. Smoke travels, it migrates. We recommend for all the buildings to implement the smoking policy that requires people to take reasonable steps and necessary measures to put caulking, to put foam, to put in weather stripping throughout to stop the migration, the infiltration, and penetration of secondhand smoke if you can't get smoking approved. We've had boards who say, for future generations, the board has the right to say we won't even consider people who are smokers for applicants for either subtenants or for sales. That's even if you can't pass a proprietary lease amendment. So.
You can do that with the house rule.
Yeah.
Correct.
There's one more question.
I just wanted to speak to a board member verifying if there's smoke coming out of an apartment. The fact of the matter is that most people work during the day and then they're home in the evening and that's when they smoke. And our staff does not work past 4:30, 5 o'clock at night. So if these people aren't getting home until 6 or 7, are we going to pay super for 3 hours overtime? Because, by union rules, they have to get paid for a minimum number of hours to go and see if there's smoke. We had a situation in our building where we had a problem with the unit where there was an excessive smoker. When that unit became available because we didn't renew the lease, it was a rental. The owner of that unit put on the lease for the new tenants that it was no smoking unit. The 2 people came in for the interview, they swore up and down they didn't smoke. Lo and behold, they hadn't even moved in. The owner had given them access to come in and clean the apartment. We're getting complaints that there's smoke coming out of the apartment. I went down to verify, and sure enough, there they are smoking away. And meanwhile, they had sworn up and down they don't smoke. And then they were smoking constantly, smoking outside. And then we finally settled it because, by telling the owner, you need to let them know and enforce that you have, because it's on the owner, they have the lease with them. And just to let you know, we've been getting a lot of complaints and we're not renewing the lease because our leases are up yearly, so they would have to reapply every year for the lease and they weren't going to get renewed. And so that finally put a stop to it.
And that's very helpful when the lease expires in a year, right?
By the way, just one little note, if you're super to live in super, you do not have to pay them the 4 hours. It's only if they live off the property that you have to pay them. You do have to pay overtime when the super goes out after his 8 hours tour, but supers generally work, they're supposed to work 8 out of 16 hours, and I don't know any super that works 8 hours straight. So I would enforce that a little way. And we have a last question right here, we're running out of time. Yeah.
Does anyone know of any detectors that can be put out in the hallway to identify smoke, where it's prominent, what kind it is?
I'm sure there's something.
I mean, obviously smoke detectors are different than smoking
We've seen some things about
detectors.
lights, but our lights are
are closed in. You can't.
I don't know. You know, the problem is that the regular smoke detectors are not going to detect that.
Right.
And then the question is, even if you have something that does, it may not tell you where it's coming from.
Right.
So I'm going to turn it over to Caesar, but thank you for all of your questions, for listening patiently, for laughing at my jokes.
Thank you.
And David and I will be here for a few more minutes.
Thank you very much. Obviously, it was a very exciting topic because of the volume of the questions, and I think they were answered quite capably by our staff here. Tim would like a few announcements to close out the evening, and then we can all go home and go have coffee.
Good job.
Thank you, and good evening, everybody. As mentioned, I'm Tim Foley. I'm the Executive Director of the Building and Realty Institute, BRI. I am on day 19, so I want to thank all of you and our speakers for making day 19 so informative and educational and social and wonderful and everything that BRI can do. I just have two very quick questions for you. You will find, very quick announcements for you. You will find at your tables a blue form. That is our feedback form. Please, it is anonymous. You don't have to put your name on it unless you want us to get back to you for some reason, at which point you put your name on it. But let us know what you think of this program or other types of programs that you want to see. If you are a member of the CCAC Board of Directors, could you raise your hands? Board of Directors for CCAC. Look at these folks. If you have other suggestions for these types of programs or more things that you would like to see the CCAC doing for you, information you're supplying, talk to me, but also talk to them. Tonight was very much their idea in terms of a program that they thought would be interesting information that would bring a lot of people together. Even by how full this room is, they were absolutely right. So let's keep that conversation going. And then the last thing is we're focused a lot on different efforts around advocacy, particularly with everything that comes out of Albany these days. One of the things is that many co-ops were surprised to find was that they were in fact included in the rent reform laws, some of the provisions of it that were passed in Albany last year. There are efforts underfoot to exempt co-ops from some of the more onerous parts of rent reform. BRI is going to play a role on that in Westchester. The New York City co-ops are already on the job. We're going to try and partner with them as much as possible. Keep your eyes peeled in your inbox. We'll have an online petition started. There are various bills within Albany that would exempt co-ops from the rent reform laws that were passed. And we want to try and support efforts to undo some of the unintended consequences of that law, in this case and many others. Those are all the announcements that I have for you. Thank you so much for being here, and thank you again to our terrific speakers.